Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer with Samfiru, Tumarkin LLP, located in Toronto. It's December 12th and 2024. I'm happy to be back with you guys. I've hosted many of these question and answer sessions. So happy to do one again before the end of this year. As you know, we have offices across the country. We have offices in Ontario and also in British Columbia and Alberta. And we host many of these Q&A sessions every week. And the goal is to get all of your employment questions answered. We are legal experts in employment law, and we're offering these sessions for free so that people understand what their rights are. What are their employment rights? What are their workplace rights? If you're facing issues with your employer, which unfortunately many employees do, how can we help you? That's what these question and answer sessions are about. So please don't be shy. Ask your questions. I'll get to as many of them as I can throughout the approximately half an hour that I'm with you. Now, before we get started, as I always do, I like to start off with an important trending issue in the world of employment law. And so what we'll talk about today to start us off is the fact that we've become aware that Mohawk College has cut about 20% of their admin jobs. So administrative jobs for the college, about 20% of them have been cut. Many terminations are happening as a result, and there's more expected to happen in the new year, likely in January. Now, the implications are different for different types of employees. So if you're unionized employees who have been terminated, then really your rights are going to fall within the collective agreement. The collective agreement that your union has with the college is going to dictate what your rights are and what procedures you can use to address the termination. Our firm is there to help non-unionized employees who are let go from the college. We are experts, as I said earlier, in employment law. We help thousands of individuals with their employment law issues. And so if you have been affected or someone you know has been affected by the job cuts at Mohawk College, and if you are non-unionized or the person you know who has been affected is a non-unionized employee, have them reach out to us at help@employmentlawyer.ca, and we will assist as quickly as we can with the termination. We'll arrange a consultation. We'll discuss what happened. If you've been terminated, have you been offered severance? How much? And often there's not enough severance being offered, and we will be able to assist you with obtaining the proper severance entitlements. A few things to note is that severance includes all elements of your compensation. So many people believe that it is only your base salary, but that's not true. If you earn commissions or bonuses, or as many employees are enrolled in a health plan or broader benefits plan, all of those things are your entitlements over the period that you're owed severance. So not just your base salary alone. Additional thing to note is even if your employer who's let you go is going through some sort of economic crisis, financial troubles, whatever the case might be, that doesn't change the fact that you're owed severance pay. That employer is not relieved of providing you with the severance that you're owed simply because of the economic troubles they're facing. It's unfortunate if an employer is facing those troubles, but it doesn't extinguish your rights as an employee to be paid out the proper amount of severance if you're let go, and your employer has to do that. So don't feel as though your rights don't exist anymore, even if you're working in an industry or for a company that is being affected by a poor economy or whatever the case might be. So that's an important topic to start us off. I'm now going to start delving into the questions that have been asked of me. So let's start with a question on YouTube from Sarah. Okay, are there any situations where an employer is allowed to refuse to pay overtime? Okay, it's a good question. There are situations. One thing that's important to address in this regard is that you have to look at two things. A, there's the law, and in Ontario, it's called the Employment Standards Act, and what they say about overtime. And depending on the industry, there are different overtime rules that might apply. So that's one area that we look at. The other thing is your employment contract. What does your employment contract say about overtime? It's very common that employment contracts will say that before you work overtime, you actually have to seek the permission of the employer. And if you don't, there could be consequences. So very important that you follow those procedures. And as long as you do, and you work the overtime hours and they've been approved, then you should be paid for them. If you're having issues with that, certainly contact us, and we'll arrange a consultation. And we'll determine if you've been paid overtime, how much, is it insufficient? Is there a reason why your employer is withholding it? What industry do you work in? All of these things are relevant factors. So contact us again at help@employmentlawyer.ca. As well, we have a wealth of information online on our website at employmentlawyer.ca. You'll find tons of resources and tools there on varied topics related to employment law, overtime being one of them. Okay, let's move on. We have a question on YouTube from MP. Does an employer have to facilitate a process where we would require banking of paid sick if unused at the end of the year? Okay, so important thing to note about sick time. First of all, in Ontario, under the Employment Standards Act, employees are entitled to 3 unpaid sick days. They are unpaid, but they have job protection during that time. If they want to utilize them, then usually employers permit that. There's new law in Ontario that says an employee doesn't need a doctor's note to utilize that 3 unpaid days. But if an employer is suspicious as to whether the employee actually requires the sick time, an employer can seek some sort of evidence that they actually require the time. Now, that's just the minimum entitlement that employees have. If you are an employer that provides additional sick time in addition to what the minimum amounts are, and MP says that they do, then really it's going to go back to what your policies say, and what the employment contract says. So sometimes the employment contract might dictate how much sick time an employee receives. It could be in a separate policy. But that is going to set out the procedure, or it should set out the procedure of the amount of days that an employee has and what happens upon the end of a year, and in terms of whether the employee has to be paid out that amount of time. But it's important to note that anything over and above those minimum 3 unpaid days is a contractual entitlement. If the contract says that an employee gets it, then employee gets it. What happens if the employee doesn't utilize it? It depends. Depends on what the contract says. Okay, so we'll move on. We have a question on Facebook from Steve. I was let go from my contract 2 months before the contract term ended. It was a 3-year contract. Am I owed any sort of severance for this? Okay, so good question. We're talking here about a situation of a fixed term contract. Many employment contracts are not for a fixed term, they are indefinite. And when you are an employee working on an indefinite term contract, and you're let go, if you're let go without cause, then you're entitled to severance pay. And the severance pay is either going to be the amount that is dictated by your employment contract. And if you don't have an employment contract, or if there are issues with your employment contract, then you're going to be entitled to severance pay based on various factors. And those factors include your age, your length of service, your position, and generally the availability of similar employment opportunities in the job market at the time of termination. And so that's if you're terminated without cause. Your employer doesn't have to have a reason to terminate you. They might have a reason. They don't have to tell you the reason. They're just letting you go, and they have to pay you the proper amount of severance. Now, what's important to note in this case is that if you're on a fixed term contract and you're let go, typically you're going to be owed the amount of money that you would receive until the end of the contract. Okay. So if you had 2 months left, you're certainly going to be owed those 2 months. If there are issues with the fixed term contract, then you might even be owed your severance pay instead of the 2 months. There are situations where it's going to be more beneficial for an employee to receive the rest of the duration of the fixed term contract, as opposed to severance pay calculated using the regular factors that I went over: age, length of service, position, etc. So each case is different, but typically if you're on a fixed term contract and you're let go, you're going to be paid out, or you should be paid out, until the end of that term. In this case, in Steve's case, it would be 2 months. But potentially, let's say Steve is an employee who's worked for 3 years and he's 65 and he earns $200,000 a year. He's probably owed more severance than 2 months of pay. And so if there's a way for us to legally get him his severance pay as opposed to just 2 months of contractual damages, we would seek the severance pay in that case, because it's more lucrative. We can't just choose what we seek for the employee. It will depend on what the contract says and whether there are issues with the contract permitting us to obtain severance as opposed to just those contractual damages. So I hope that helps. Fixed term contracts are always a complicated situation. Doesn't change the fact that you're owed your compensation. If you're on a fixed term contract and you're let go, it's not really all that complicated, but we just have to do some analysis of the contract and determine what your entitlements are as a result of the breach of the contract. So we have another question on Facebook, rather, from Mary. I work for an American company, and recently they changed how they're going to pay us commission. In the middle of Q3, they announced that they were changing one of the measurements of commissions. Now I understand that the companies are allowed to change their commission structure, but are they supposed to give you a heads up? Okay, so if you're working in Ontario, even for an American company, likely you're going to be considered an Ontario employee. Excuse me. So we deal with those situations all the time, where there's an American head office, but there is an Ontario subsidiary, and you work for that company. You're an Ontario employee, especially so if you're located in Ontario. Now, just like other employees who work in Ontario, if you work on commission and the employer changes the way the commission is calculated, they have to give you notice of that. If they don't give you notice of that change, then it is arguably a termination. If there's a substantial change to the way that you're paid your commissions, whereby you're going to be earning, for example, less money, and you didn't get notice of that change, then that is a dismissal of your employment. That's what we call a constructive dismissal of employment. What that means is that your employer is not terminating you outright. They're doing something without your consent that substantially changes the terms of your employment. In this case, the term of employment at issue is your pay, right? Pay based on commission. And if you don't consent to the change of the way the commissions are paid out, then your employer is doing it without your consent or doing it unilaterally. And if it is going to have a substantial effect on how much commission you receive, then that is what we call a constructive dismissal. In a constructive dismissal, you're owed as much severance as you would normally be owed if you were let go. So again, we go back to those factors: your age, your length of service, your position, how much money you're earning, and generally the availability of similar employment. If your employer does provide you with sufficient notice of the change, and how much notice is going to depend on how long you've worked for the company and your age and your position, et cetera, the same factors. If you're provided with notice that's sufficient, then they can make that change. But typically, they're not providing you with that much notice, if any notice at all. Usually, if an employer's changing a term of your employment without your consent, in my experience, it's going to be without notice, and therefore you can pursue a constructive dismissal. Now, we talk obviously in these sessions a lot about severance and how it's calculated. So at this point of the session, I want to raise a tool that we have. Our firm created what's called a severance pay calculator, and you can find it as part of our Pocket Employment Lawyer tool. And so what this tool does is it determines how much severance you're owed. It's a free and anonymous tool. It will ask you questions based on what your age is, what your position was, how long you worked for the company, how much money you earned, and then it will dictate how much severance or a range of severance that you could expect to receive. I encourage all of you to use this tool. Again, it's free, it's anonymous. If you haven't been terminated, you can still use the tool so that you have an idea of what your entitlements might be if you ever are let go. And certainly if you or a family or friend have been terminated, then absolutely use the tool, determine how much severance or the range of severance, as I said, that you might be entitled to, and then we'll arrange a consultation with you. Contact us after that at help@employmentlawyer.ca, and then we will ensure that you are provided with the right amount of severance if you've been let go. Again, check us out at pocketemploymentlawyer.ca. Okay. I have a question on YouTube from Positive Living. I am on short-term disability. My average compensation, including bonus, is around $120,000 over the last 2 years, but my company is only paying me on insurable earnings, which is average of only $60,000 for the last 2 years. Okay, so again, this is going to go back to contractual principles. But really what's at issue here is bonus payments. When you're on short-term disability, you're going to be paid by your employer, and they should be paying you based on what your actual compensation is, which in this case, including bonus, would be $120K. But it depends on what your contract says as well. So we have to look at any bonus policies, or the employment contract itself might have a section on bonus and when it's payable, how it's payable, in what circumstances it may not be payable. So that is a very relevant thing to look at in order to determine whether you're going to be paid a bonus at all, whether you're on short-term disability or not. We look at these bonus provisions to dictate how much severance an employee would get, whether that severance includes bonus, just as much as we look at the policies to determine whether you're paid a bonus during your employment, even if it isn't part of severance. So all in all, we got to look at these bonus policies that might exist. Sometimes employers don't have bonus policies and employees are just receiving bonuses, and it's not actually written in stone in any sort of policy or employment contract. That's a different scenario. But if you want to arrange a consultation so that we can review your documentation, which include the employment contract. And if there's a bonus policy, that as well, we can provide further advice on whether those bonuses are payable and part of the earnings that you should receive, whether you're an STD or not. So let's see. We have a question on YouTube from Greg. I'm eligible to retire at my current employer. There are certain benefits that I want to preserve. I have been considering opportunities elsewhere for higher level positions and a different challenge. I'm aware of typical notice periods for retirement. However, if I receive an offer of employment elsewhere, including at a competitive company, could my current employer terminate my employment and not permit me to retire? Okay, there's a lot baked into this question, so we'll try to break it down. So, first thing to note: if you retire or you resign, you're not entitled to any severance. Okay, so before you do that, you want to think very hard about whether you want to actually give up any severance entitlements, especially if you think it's possible you might be terminated. If you might be terminated and therefore that triggers your severance pay, you certainly would not want to go and beat the employer to it and retire or resign and thereby give up your severance entitlements. So first, very key principle: you resign, you're not entitled to your severance pay. If you resign, yes, there are notice periods typically that are set out in your employment contract. So you have to look to your employment contract. A very common notice period is a 2-week notice period. So the contract will say, in the event that you resign, you have to provide the employer with 2 weeks of notice. It could be 3. It depends on the contract. It varies. 2 is just a typical amount. And you should comply with that contractual provision that says how much resignation notice you must give the employer. If your company terminates you, as you noted, then they will owe you severance pay. In that scenario, you haven't resigned yet. If they terminate your employment, they beat you to it, then you are going to be owed your severance pay, calculated using the regular factors that we talked about: your age, your length of service, your position, your compensation, and generally how available similar positions are in the job market at that time. It could be, and this is where we get a little bit complicated, it could be that you will give up some of your severance pay that you might be eligible for if you start earning new income. So if you have a job offer somewhere else, even if you've been terminated by your current employer, and then you have a job offer waiting for you, then you might get your minimum termination entitlements, because there are minimums, but your maximum termination entitlements you may not get, because you've earned new income now, or you will earn new income from the new employer, and that income could offset the additional severance on top of the minimum amounts that you might be able to receive. So for this kind of situation, I certainly recommend a consultation. Contact us at help@employmentlawyer.ca, because there's lots of strategies that have to be used in order to preserve your rights. Again, you don't want to resign in most cases if you're going to give up your severance pay. So we have to deal with how to work with a new employment offer in a strategic way to preserve your rights to the extent that we can. So again, contact us at help@employmentlawyer.ca, and absolutely we can arrange a consultation. Okay, lots of good questions today. We have a few minutes remaining. Let us go on. We have a question on YouTube from Ira. If I don't sign my employer's severance offer by the requested deadline, what happens? Typically nothing happens. And in fact, I'm asked this question multiple times every single day. Usually a good part of my day, I set aside time to speak to prospective clients, not clients of mine currently, but hopefully future clients. And they want to arrange consultations with me to determine what their workplace rights are, if they've been let go, what severance entitlements they have, And almost always, if there is a termination offer, if there's a termination and there's a severance offer as part of that termination, almost always there's going to be a deadline in the termination letter. And the deadline could be a day, it could be a week, it could be 2 weeks. It really varies. And the reason why it varies is because the employer makes it up. The employer makes up what deadline they want to put in the termination letter. And really the purpose of the deadline is just to put pressure on the employee to get them to accept the offer of severance that the employer is making in the termination letter. But many employees might succumb to this pressure. I think that employees in general are becoming more educated about their rights. One way that is happening is through these Q&A sessions. We're reaching out to many people, and a lot of people are learning about what their rights are. And one of those rights are that you don't have to sign your severance offer in the termination letter by the deadline. The deadline is just made up, and your severance entitlements do not go away if you don't sign the severance offer that the employer makes by the deadline. You have 2 years to pursue your severance. Very important to note that. The law is the body that determines how long you have, not the employer. And the law says you have 2 years. And so if you're terminated, December 1st of 2024, you have up to 2 years from that point to pursue your severance. That doesn't mean you want to wait. It is in your interest to pursue your severance entitlements immediately. And that's why we always recommend to contact us so that we can assist you with obtaining your severance as quickly as possible. But it is important to know that you don't have to succumb to this pressure of this deadline. And then people always respond to me, well, if the employer is offering me $20,000 and they say I have 3 days to accept it, and if I don't accept it by that deadline, will the offer go down? What I tell people is almost always no. It isn't impossible for an employer to say, well, the deadline has passed, so we're reducing the offer, but almost always that's not going to happen. And the reason why is because the employer has already determined that they want to pay you that amount of severance. And just because the deadline has passed, that desire to pay you the severance so that you release them of liability, which means you sign the severance document saying, I'm not going to sue you in exchange for this severance money, that's not going to go away. Your employer still wants you to sign that document. So even though the 3 days have passed for that deadline, doesn't change the fact that the employer is willing to pay you the severance offer that they've made. And likely with our help, they will even pay you more. And so very, very important question. And I hope that that helps clarify a lot of issues that people have in terms of whether they have to sign severance offers immediately. Do the entitlements go away just because a deadline has passed? And so the short answer is no, they do not. You have 2 years. So I hope this was a good session for all of you. We had a lot of great questions and a lot of varied topics in employment law. We have another Q&A session on Monday with my colleague Chris, and that will be at 1:30 p.m. So join us again. If there's any questions I did not get to answer today, I apologize. We're flooded with many questions, so we get to as many as we can. But again, we have these Q&A sessions multiple times a week, so that we can answer all of your questions as quickly as possible. So thank you again. Happy holidays, everyone, and we'll see you again next time.